Welcome back. Thank you very much. Our second panel is going to probe more deeply into how we live and work with fair use, built around those 4 factors. And by the way, on your program, you will see on the very back page the full text of the fair use statute. Now, for all the things you've heard about fair use, all those things are rooted in that statute that barely fills the equivalent of a half a page of text. So there's the root of what is fair use. And that's what gives us the factors that we've referred to a few times for how we work with fair use and make decisions. And so our second panel brings different observations and ample experience from working inside different organizations where they are called upon on behalf of themselves, their own organization, on behalf of clients through the law firm, to answer questions about what is fair use, how do we work with fair use, what might our standard be. And so our 3 speakers, Cherie Carter-Galvan from counsel's office at Yale University, Bob Clarida, practicing attorney here in New York City and represents many organizations that we are akin to, and Gretchen Wagner from Artstor. All of these folks are attorneys and are going to bring that attorney perspective as well, but they're driven by many other motives. So let me bring them up, and I think we're going to do them in the order we have. So Cherie, come on up.
Well, it is certainly my pleasure to be here to discuss with you a particular perspective in applying fair use. The composition of the panels today really reflects that fair use is applied in numerous contexts and really should be understood from a number of different perspectives. I thought I might give you a glimpse into the perspective that applied when we apply fair use in the context of OpenCourseWare. I'm sure many of you are familiar with OpenCourseWare. MIT in 2002 launched its MIT OpenCourseWare initiative, and as part of that initiative, MIT made available class notes, syllabi, all sorts of resources related to actual courses taught at MIT. And MIT made all this content available under a Creative Commons license. In fact, they used the attribution, share-alike, non-commercial license, which is a very liberal license that allows the user not only to access the material on the site or view the material on the site, but users were able to modify this content, create derivative works based on this content, and then further disseminate this content downstream. When Yale initiated its OpenCourseWare initiative, Open Yale Courses, it thought about doing something a little bit different. What Yale ventured to do was create audio-visual recordings of all the lectures of specifically identified courses, and to make those audio-visual recordings as well as transcriptions of those recordings, reading materials, and the typical OpenCourseWare type of content available through its Open Yale Courses website. And similarly, Yale pursued a Creative Commons, attribution, share-alike, non-commercial license. So this presented a bit of a nightmare from a rights clearance perspective. We were dealing with content, third-party content embedded in this new educational material we were trying to set free on the world, and we really were not quite sure how we were going to address rights clearance. In fact, the OpenCourseWare providers that came before us had taken the position that fair use might not apply in the OpenCourseWare context. And we knew that there was a lot of fear involved in applying fair use. There's a saying that goes that the worst thing you can do in life is to constantly live in fear of making a mistake. And that's where we were. Librarians, faculty members, those who are managing collections throughout our university, and In fact, legal counsel were feeling very apprehensive at the time with regard to applying fair use. But I think one of the things that came out of our experience is that we almost had to experience what it would be like not to apply fair use when we should apply fair use, to understand when fair use should apply, which brings me to this first slide. This slide is the first slide, the opening slide to a modern poetry course taught by our esteemed faculty member, Langdon Hammer, and the course reads, "In some instances, materials that were projected on the classroom screen are not shown due to copyright restrictions." So, who do you think played a role in that slide? Okay, so that's to say, okay, we at the General Counsel's Office, we do make mistakes too. So this was the opening slide, and what was the kind of content we were referring to when we said some of the materials that were projected on the classroom screen were not shown? I'm going to give you a little bit of an example.
I imagine that you all have images of Robert Frost, and actual images in your mind when you think of this poet. He's a familiar face in American literature, and I gathered some of them that seem representative. This is Frost in old age as an American bard from a magazine. This is the Frost that you probably know as if he were born with white hair, right? And a kind of, kindly and monumental and yet approachable figure that is familiar from American schoolrooms. Here's another image of that same guy, Robert Frost, painted by Grandma Cox, reminding us of Frost as a kind of link to 19th century life. To rural Vermont. Another image of Frost, this one from the Times, just a little story. President Hale's bond with Frost, that president would be John F. Kennedy. On TV, he extols poet who calls New Frontier Age of Poetry and Power. And perhaps you have seen images of Frost reading his poem, The Gift Outright, at Kennedy's inauguration. It was a kind of powerful moment in American culture where the president allied himself with poetry in this way. More pictures. This is, Frost with grandchildren, Frost with his pet calves.
Okay, so
he was kind to animals.
So I'm going to stop here. I showed this clip to my children, and they were outraged. They asked, "Where are the images? Where are the pictures?" It was very disturbing for them to see this video, and I'm sure it was disturbing to many of our users. Professor Hammer is trying to make a link between Robert Frost, the man, and his poetry, and he's attempting to create context in which the students can understand Robert Frost. He's attempting to revive an image of Robert Frost in the student's mind. Professor Hammer shows approximately 10 images in the first 20 minutes of this lecture, none of which you can see. Okay. We made other decisions of this kind when Courseware first launched. Decisions like not showing a PowerPoint presentation that contained an image of a map, or not including certain poetry, or requiring that the lecturer really break up the poetry in a way that may have not pedagogically made any sense in order to make sure that we were in fair use when the poem was being recited and then transcribed for OpenCourseWare. In fact, one thing we also did is we cleared rights to use a particular translation of the Bible. And it was a very, very difficult process. And that kind of process kind of makes you start thinking, well, what if the rights holder said no? Could we not show this material? Could we not teach our population about the Old Testament or not refer to this content? I mean, it was pretty absurd, but we weren't alone in making these types of choices. And I think we reached a point of desperation because we knew we were compromising the experience, almost like what Brandon was referring to in terms of compromising your mission. You always have to keep in mind, what are we trying to do here? And is this working? And I would say this was not working. And we were fortunate because at the same time we were having these struggles, MIT and other courseware providers were having these struggles. And we reached out to Peter Yazzie and Patricia After-Heide and elicited their help in creating a code of best practices for open courseware. And we created a number of different scenarios, and you've heard what this process is about. We reached a consensus, and we even debated some of the issues, which I think is very healthy, about, well, really, is this right? Is this the right thing to do? Should fair use apply in this context? Should we request permission? And we also made sure that in having these conversations, we were also considering some of the options. Getting Creative Commons content, actually clearing the rights. In one instance, we entered into a contract with a provider of musical content so that we can play as much as music as we wanted in as many contexts as we wanted without having to go through a fair use analysis because of the fact that it was just too unclear to us and we weren't sure of the comfort zone. But what Peter and Patricia helped us do is have a conversation that took us out of this fear-based analysis into a rational-based analysis. And by having that kind of discourse, we were able to find what I call is our comfort zone with regard to fair use. And the comfort zone is not legalese, but I think part of what we should be doing in talking about fair use is create a user-friendly way of applying fair use. We need to talk about fair use in ways that people can really understand and really apply. And within this comfort zone, and this is sort of I recast what we did in the code because it was an easy tool for me to use. And sometimes I think we all have to think about how is it best that I can understand this concept. And so within the comfort zone was, for the purposes of OpenCourseWare, the use of third-party content for illustration or demonstration and explanation or critique or analysis. And we wanted to encourage those uses within our community, within the academic community. We believed all of these types of uses of third-party content was transformative, and we thought that it was helping us further our mission and further, quite honestly, the purposes of fair use and the First Amendment purposes of fair use. And outside of that comfort zone were things, I mean, you can't see some of the bubbles, but use of content for entertainment purposes. And that happens. I think people love to use content. Even faculty members love to use content, and sometimes they'll run a cartoon. They'll put up, something to make to relieve the tension in the class, and that may or may not be fair use. I think what's outside the comfort zone, I would say, are not necessarily uses that are not fair use. I think they're uses maybe that are more risky, or uses that might be out of my comfort zone or the comfort zone of my institution. And one thing I really want to encourage is I want everyone in this room who's not a lawyer to recognize that the lawyers in your institution are actually there to provide advice. And, they're busy. I'm busy. But I think it may make sense to share some of your ideas about fair use and to start the conversation with your legal counsel and have a productive conversation about the kinds of things you wish to do and how you want to apply fair use so that you can come up with a common understanding within your respective institution, because institutions have their own cultures and they also have their own sensitivities about risk. And that's what happened, actually, out of our Code of Best Practices for Open Courseware. Yale was lucky because I participated, along with my colleague who's here, Pamela Chambers, in developing these scenarios that ultimately resulted in the code. But at the end of the day, I had to discuss this with my general counsel. And she had to bless the code. And in some instances, you can get a blessing and with some reservations. Sometimes you'll get, well, you know what, I still want you to come back to me when you want to do X or want to do Y. And I think by having those conversations, maybe that can relieve some of the nervousness about being out there alone, making these decisions and assuming risk on behalf of your university. And I don't want to hear every case. You know, I don't want to get besieged with requests and questions about does fair use apply in this context or does fair use apply in that context. And that's not what happened in the context of OpenCourseWare. In fact, we created the code and we pretty much stepped away. And when there was an issue, when I knew, oh, there was a class that was being presented that had a lot of content of some type, particularly creative content, what we do is we pass the code on to the faculty member. We'd say, read this, digest this, and let me know if you have any questions, and maybe this will be your guide in knowing how fair use would apply in your particular context. Now, we had a special problem with OpenCourseWare, and I'll call it the elephant in the room. And the elephant in the room was how to address fair use for copyrighted material incorporated into content licensed under Creative Commons. And it's true, in all likelihood, if whatever the end user did was really the end user's problem, but we wanted to act responsibly. And I think it goes a long way in your relations with rights holders generally to make reasoned decisions and to behave fairly, even if there's no law that's requiring you to do so. So what we did for OpenCourseWare is we made sure that we made every attempt to attribute when reasonably possible. We didn't just take third-party content and slap it up there and say, well, it's fair use and it's instructional or it's illustrative or we're demonstrating a concept and fair game. But we made sure that, well, we let the user know where this content came from and instruct the user that actually, you know, you can't take that poem that we just described and do whatever you want with it. You have to make some judgments on your own. And that's our responsibility to make sure you understand that. Not in all instances could we attribute the content because OpenCourseWare isn't a publication in the typical sense. OpenCourseWare contains material that faculty members pulled together, gathered, sometimes on a whim, without any thought about having to publish or disseminate. And in some instances, we couldn't figure out where this stuff came from. And in those instances, we couldn't attribute. But what we did do is we tried to put in a little language in our terms of use that says, you know, if you know of any information regarding our material, let us know. So that brings me to a final bit. And that regards the different tools we have at our disposal when copyright doesn't do justice to what we have to do. Fair use is a great tool. I think it's wonderful. But I also think that we need to start asking our federal relations people to really fight hard for some changes in the copyright law and start carving out protective areas for us. Internet service providers have some protections when there are materials on their sites that really don't belong there, and they can walk away and no harm, no foul. And I think we need to start thinking about what kinds of improvements we need to see in the copyright law and fighting for those changes. And one colleague of mine at another university, I asked her, well, what do you do when you don't, for example, you're dealing with orphan works, you think fair use applies, and it probably does, but you want to be fair and reasonable, and you don't know who to call or what to do. She says, well, we put in information that says, if you have rights to this material, please send us an email, let us know, let's have a conversation. We have that same issue at the Beinecke, that houses many, many images, and some of the images, we purchase these images, or they're donated to us, and these collections have so many rich images, and we don't know where they came from, who the copyright holder is, but that doesn't necessarily mean we're not going to make this material available. But we do have some language that says, if you have information, let us know. And at least in a couple of instances, we've had rights holders come back to us and say, hey, that's mine. And then we say, well, look at what we're doing. Isn't this great? And sometimes, and I would say in all cases, they say, yeah, that is great. Thanks. Just make sure you attribute me as the owner. So I'm sure we'll hear more, and this has been, I cannot tell you how delighted I am, because the information we're hearing today and the perspectives are very, very rich, and I very much appreciate participating today.
Thank you very much.
All right, thank you very much, and it is really wonderful to be here, and I have a number of clients in the room today. I do work with a number of universities and libraries and nonprofit institutions of all kinds who have these issues on a regular basis, and what I'm going to try to do is to just sort of, in a very abstract way, sort of walk through the process that I would use with a client who comes to me and says, is this a fair use? The question about is it a fair use, there's some grumbling, some understandable grumbling about why can't we ever get a straight answer, is it fair use or not? Is it fair use is a question is sort of analogous to is it going to rain tomorrow? You can often have a pretty good idea, but you're never going to be completely sure. And then there are some situations in which you really even wouldn't want to try to guess, because it's just a toss-up. So the facts are always incredibly important, and what I'm going to be talking about are some general principles that apply pretty much no matter what your facts are. First of all, I don't like to think about these questions in terms of is this a fair use or is it not a fair use. It's a bigger question than that. The question is, my institution wants to do a particular activity. Is it a safe thing to do or a risky thing to do? How safe is it? How risky is it? Because ultimately what you're going to decide is either to do the activity, not do the activity, or change your plans a little bit to make the activity a little bit safer. Fair use is part of that analysis, but it's certainly not the entirety of that analysis. The first thing I would ask in every case, and this has come up a couple of times already, is there a contract in place? Because if there's a contract in place, if you're licensing from a database, let's say, and you've got terms and conditions that you've agreed to, those terms and conditions will govern. And there is case law that says if a contract takes away your fair use rights, that's enforceable, folks. That's an enforceable contract. People can contract away any rights they may otherwise have under the Copyright Act. If you're a copyright owner, you're contracting away your exclusive right to distribute the work. And if you're a copyright user, you may be contracting away certain fair use rights. So you have to be really careful, and when you're doing these negotiations, you often don't have an awful lot of bargaining power. You get pretty much a contract of adhesion. These are our terms, take it or leave it. And that's a very bad position to be in, but once you've taken it, it's going to be difficult in some cases to argue, oh, but it's a fair use anyway. If the agreement is really written in a very draconian and detailed way, you may not have a lot of fair use left to argue about. Second issue that always comes up is, and this is all in the category of risk analysis or risk management. There's always some risk, and your question is how do you best manage it? Is the copyright owner going to know you're doing this? Very often they don't. If you're putting something up on the web, you can be sure they will find it. But if it's not up on the open web, many, many times, the copyright owners will never know. How likely is it that this is going to be, you know, a public issue? If you're doing something on a large scale, you have to assume probably it's going to happen. But if somebody comes to you, can I do this in my class on Tuesday? Probably nobody is ever going to know or care. Second question is, if the copyright owner does know that it's happening, would they care enough to want to sue you about it? Odds are probably no, particularly if it's one of these sort of day-to-day kinds of questions that come up about something that's going on in a classroom. If you're digitizing a whole gigantic collection and putting it on the internet, yes, they might care enough to sue about that. There might be enough of an incentive. But, you know, bear in mind that all the costs that are associated with litigation for your institution are also associated on the plaintiff side. It's not free for plaintiffs to bring lawsuits, and very often they don't bring lawsuits even when they have good claims. I represent a lot of plaintiffs too, and very many times my clients choose not to sue for various reasons. One being that it gives them a black eye if they're going to sue this, you know, wonderful public-spirited institution. That they don't want to be the black hats in that scenario. And also, it costs a lot of money, and they're probably not going to get it back. The Copyright Act does have fee-shifting provisions in it, that if a copyrighted work is registered before the infringement commences, fees can be shifted to the prevailing party. That is, the loser will have to pay the winner's fees. But that's discretionary with the court, and it doesn't happen as often as you might think. And particularly if you have a pretty good fair use argument, and you're a nonprofit institution, the odds of a plaintiff recovering attorney's fees in that situation are pretty low. So it's a very large cost to a plaintiff to proceed with a lawsuit as well. So you have to factor that in. There's a sort of a climate of fear, I think, that people have, that copyright owners are just, you know, waiting to swoop down and attack, and that's generally not the case. There are some who are obviously more aggressive than others. Then you have to think about what is the cost of, if a lawsuit were to be commenced and you were to lose, what would the cost be to the institution? Certainly the cost of defending it is large, and probably you would have outside counsel rather than in-house counsel of the university, if you work in a university, handling the litigation. That would be a large expense, and that's certainly not something to take lightly. Against that cost, you then have to think about, well, what are the costs of avoiding a lawsuit? What are the costs of licensing the material in the first place? I was just in a discussion last week for a client who's a big hotel here in New York, and they were talking about, oh, well, you know, we want to do this, we want to have this art exhibition, we want to do this and that, and we want to put brochures. Okay, well, are we going to, you know, is this a fair use? No way is this a fair use. You're a hotel, you want to bring people in, you're putting out brochures to, you know, come look at the art in your hotel. It's a selling point, it's advertising. And so we're going back and forth, and, you know, the cost of getting a license to do what they wanted to do would have been $1,000, $1,500, certainly less than the cost of lawyering it for 2 hours. So taking a license may be a point of principle sometimes. I'm not going to take a license. I have a fair use. You may have a fair use, but it may still be the better part of valor to take a license. That's you know, that's the way disputes get resolved very often, is by compromise, and that can sometimes be a very attractive compromise. Also, you have to think about, are there other ways to accomplish what it is that you want to accomplish? And I'll use an example of a large religious organization that I work with, and they were having a big national meeting of people from all over the country coming to this big meeting, and they had hymns that they wanted people to sing. And as you may know, the Copyright Act has certain public performance exemptions under 110 for religious services, but this didn't qualify for that. What they really wanted to do, and what they were asking me about, was, can we photocopy and hand out copies of these hymns so everybody can have the hymns? And would that be a fair use? And start looking at that and say, well, gee, you're a nonprofit, this and that. You can go through the whole fair use analysis, but ultimately there's a provision in Section 109C of the Copyright Act that says if the people are present at the place where a copy is located, you can display a copy on a screen with a projector like this, and so you have one copy. It's a legitimate copy. You put it on an Elmo, and off it goes onto a screen, and everybody in the room can see it. No copies are made. The public performance is okay under 109. You don't have to have the fair use argument. I'm not saying that would work for very many circumstances at all, but there are other ways very often to get the result that you're trying to get with fair use. And sometimes a simple sort of rethinking of the way you deliver the content can make a big difference. For example, people are hosting content on servers now. Rather than putting the content there, they're allowing their servers to be used by people to host content. If you are a service provider, an internet service provider under the DMCA, you have no monetary liability if you are hosting content that is there at the request of users, and you can respond to a takedown notice if and when you get a takedown notice. And that's a lot easier than making a fair use decision about things. That takes you into a different business. You're not building a collection and presenting your collection. You're hosting material from other sources. But it's something that certain clients of mine have been thinking about to take advantage of the DMCA, because after all, a lot of times if you're looking for a particular example in a scholarly setting, I have a course here at Columbia Law, I'll find things on YouTube. I really do find things on YouTube, and YouTube is a great resource for things that I want to talk about in my class, and YouTube is protected by the DMCA because they're hosting this incredible body of content. So there are sometimes ways that the technology can allow you to avoid what would otherwise be a pretty significant risk of copyright infringement. And then finally, all of these considerations about the cost of litigating and would the copyright owner care enough to sue you and all those sort of things, those are all costs and negatives. You have to balance that always against the benefit to the institution of doing the activity. It is, after all, a cost-benefit analysis. It's not just a cost analysis. So you have to say what purpose is really being served to this institution and to the students, the faculty, to the people who are part of this community by doing this activity. And if this activity has a great public benefit, a lot of these risks might be bearable. And if the public benefit is, well, we want our students to have, easy access to movies on their iPads and save them a Netflix subscription, that's not a very good public benefit. That's not a very good institutional benefit. And that's the kind of benefit that, in a fair use analysis would not serve you very well if you couldn't make a very good argument as to why this is serving the purposes of copyright. Another point that's related to that is that in fair use cases, the optics, the atmospherics matter a lot in these copyright cases. And you can go through the list of the 4 factors, and you can look at Judge LaValle's article on transformative use, and you can understand that as well as anybody in the world understands it. And if what you're doing looks like piracy, you're probably still going to lose your fair use argument. And there's an example of a case involving, again, it was in a religious context, another nonprofit religious organization that was distributing books. It was a splinter group of a larger organization. A larger organization had published a book that it was no longer circulating. Splinter group takes the book and starts republishing it and distributing it, handing it out free on street corners. That's just pure piracy. That's taking somebody else's work and reprinting it and giving it away, distributing it publicly. They're a nonprofit institution. There's no market harm because the plaintiff was not selling this work anymore anyway. The plaintiff had withdrawn this work, repudiated this work, was never going to publish this work again. No conceivable market harm. Still, it was not a fair use because all you're doing is taking an existing work, making copies of it, and giving it out to people. That was not something that was a compelling sort of public benefit in a fair use context. Also, public benefit is not necessarily the same as transformative use. A transformative use is a kind of public benefit. The public benefits from having more speech, more commentary about existing work. You're making a new work. You're giving a work a new purpose, new message, new meaning, all of that from Judge LaValle's article. But there's also a kind of a public benefit that can come just from keeping a work from disappearing. That's a public benefit as well. Public benefit is a concept that comes up in the legislative history of Section 107. And in connection with a project I was working on involving film digitization, there's a great discussion in the legislative history of Section 107 that talks about it would clearly be fair use to make copies of films that were deteriorating, and to have preservation copies that would clearly serve a great public benefit and be a great candidate for fair use. Well, that's not really transformative in a way. That's taking a film and saving it so it can still be a film. You're not using it for a different purpose. It's still going to be the film it is, and you're going to watch it because it is that film. You're not making a new work out of it. You're not really even putting it in a new context, but you're doing a great public benefit of keeping that film from disappearing. So the concept of public benefit is broader than Judge LaValle's concept of transformative use. So when you think about, oh, well, the use we're going to make here is not transformative because we're not commenting on the work, we're not making a new work out of it, you still might be providing a great public benefit. And if you are, you could still have a very strong claim to fair use. And I think because of the time, I will leave it there, and I'll be happy to take questions after we open it up for the floor. Thank
you. So good afternoon to all of you, and thanks so much for coming today. Since the topic of today's discussion is in large part about really how we roll up our sleeves, or at least this is how I perceive the conversation. How do we roll up our sleeves as a practical matter and rely on fair use? And today, in connection with that kind of broad mandate, I started to think about what does this mean for Artstor? What has it meant for Artstor? Because we've relied on fair use for the past 10 years. It's really been a very critical component of our fair use strategy. So for those of you who are unfamiliar with Artstor, it's a nonprofit organization that was founded by the Andrew Mellon Foundation to utilize digital technologies to further research, teaching, and learning. And so within that broad mandate, one of the things that we do is to make available an ever-expanding library of digital images in the arts and humanities. And so the library right now has about 1.5 million images, with another 1.5 million images in the production queue that will be made available over the next couple of years. And the library is available in 1,400 institutions, nonprofit institutions, in 45 countries worldwide. So to frame our fair use discussion today, I want to sort of note not only have we been relying on fair use for 10 years, but we rely on fair use for about 20% of the images in the library right now, at least. So it gives you a sense of sort of, if you're talking about, and here I want to knock on wood, because I've become superstitious since I've taken the job of General Counsel of Artstor, but to the extent that we are sort of the canary in the coal mine, there is one way to sort of look at this question. So back when we started to look at copyright issues 10 years ago, we realized that given the scale of what we were trying to accomplish, of building this ever-expanding library that would meet educational needs, and given the, what I call the kind of traditions around images, the traditions of permissions around images, we realized that there was no way we were going to be able to obtain permissions in every instance. So for starters, as was referred to earlier, there are many, many orphan works in the image context, particularly with respect to photographic works and non-Western art objects, and I could go on, where you can't reasonably identify the copyright owner. But perhaps more importantly, what we understood after looking at this question, and frankly after undertaking an initial permissions effort, was that there just aren't those traditions of sort of easy or efficient permissions mechanisms in this context. So you write letters of permission, you frequently don't hear back. And if you hear back, it's inevitably a conversation about image quality and attributions and data quality. And while those are all fine and productive and useful topics, the point is there's no way to sort of do this at any kind of scale that would sort of fulfill our broader educational mission. So we, at that point, started to really very seriously look at fair use, and as the only way that we could achieve our educational mission. And it is because that's the sort of basis for my gray hairs today. But back from 10 years ago when we started this analysis, because the laws obviously at that point was so, was sort of all over the place on these questions. In developing a fair use strategy, so one of the first things we did was to better understand fair use jurisprudence, and we got the superb assistance of Bob Clarida. We are one of his clients. But the next thing that we did was to develop what I call an environmental scan. And when you're thinking about developing a fair use strategy, particularly, so much of us today are engaged in large-scale digitization or distribution efforts. And particularly when you're involved in one of those projects, I think one of the initial steps that you can take is to undertake this environmental scan. So what we did was to look and see what other users were doing in our context. What are other educational users doing? Are they obtaining permissions? Are they not? If they are, why are they doing that? And we also tried to understand what the universe was of rights holders and what were their concerns. And so one of the things that we uncovered in undertaking this analysis was that first there was this century-long tradition of relying on fair use in our context. And I have to just back up and say, I wish at the time we'd had one of these fair use statements that Brandon and Peter and Patricia have been involved in as we were undertaking this environmental scan. Because frequently, these fair use statements can give you a piece of this environment. They can sort of let you know about what the sort of community practices are. And that can be tremendously helpful as you're sort of starting this sort of first point of understanding the landscape. And so as Brandon so graciously noted earlier, I was involved in the development of a Visual Resources Association fair use statement for the use of images for teaching, research, and study. And Bob was on our advisory panel for that. And as was Virginia Rutledge, who's somewhere in the back of this room. The point of that was, though, really in part to document community practices. And so when we were doing this for Artstor, we were able to point to these same community practices. So there was a century-long tradition of relying on fair use. There were long traditions of rights holders not challenging this practice and not trying to require that users obtain permissions. And so we were able to document all of that. I think it's really important to note, though, that even if there are not those same traditions, so even if there's a sort of active licensing effort being undertaken by the community, it's okay still to rely on fair use. You don't have to point to those types of practices, and you don't have to point to sort of what others are doing. So that's the parenthetical I have on that first point, that even if others are relying on fair uses in certain ways and you're not, you may still very well be able to rely on fair use. This leads me to the second point about developing a fair use strategy. And that is, I found it tremendously helpful when we were first undertaking this effort to develop a fair use or copyright statement that was then posted on our website. And the point of this statement is really to lay out the equities of what you're trying to do. So it's to put your fair use argument in that kind of broader context or framework. It's to say, here's the background for why we're doing it. It sets the tone. It says, here is what we're trying to accomplish. And in part, you're trying to do that for the community that you serve. In part, you're trying to do it to get ahead of the potential copyright plaintiff. Because if they come to you, as may be the case, this document may help frame the set of arguments that you have. And it may also help you demonstrate good faith. And here, we talked earlier about the 4 fair use elements. I want to argue today that there are now 5. And I think good faith, as Bob was alluding to earlier, is really an important element at this point. So the optics, as he said, matter. And we're now seeing in a lot of the recent cases, certainly in the Shepard Ferry case, but in the Cario or the Bill Graham Archives case, we're seeing courts look at the good faith or lack thereof of the plaintiff or defendant. So when you're developing your fair use strategy, one of the things that we've done at Artstor, and one of the things that was pointed out in the ARL and other statements, is we employed a number of mechanisms to help demonstrate our good faith. So we use terms and conditions of use. Our terms and conditions of use don't preclude fair use, but we use terms and conditions of use. We have digital rights management technology. We employ a set of provisions there that are designed to protect the rights of copyright owners. And I want to note here, it's really important, you don't have to employ these things to rely on fair use. Fair use doesn't require that you have terms and conditions of use, or that you employ digital rights management. But what it does do is potentially help demonstrate your good faith. So again, to the extent that you are trying to demonstrate good faith, that may be particularly helpful. I think of these kinds of protections as really being sort of reasonable accommodations that don't hinder your broader mission, that are designed to demonstrate that you are trying to be respectful of copyright owners' interests. The fourth thing I would say about any fair use policy is to note that, as was suggested earlier, it doesn't have to be a sort of all or nothing approach. So one of the very real limits of fair use is its geographical boundaries. As probably most of you know in this room, fair use exists in the US, and I'm delighted to hear that there are some efforts to push this forward in other countries. But as it stands right now, it really does not, by and large, exist outside of the United States. And to make matters more complicated, when you're distributing globally, such as on the open web, the question of which law applies is really an unsettled and kind of murky one, much to my horror when I was looking at this. So for Artstor, this has meant that when we distribute the library abroad, in some instances we have a smaller library that we distribute abroad. We pull some images. We're relying on those images for fair use in the US. We don't necessarily do that abroad. We also, in some instances, obtain permissions from copyright owners, and one of the reasons we do that is because we want to be able to serve educational users abroad. So my point here is that you can have a nuanced approach to copyright in your policy. It doesn't have to be sort of all or nothing approach. And in fact, the law is very clear that if you would go and you try to obtain permissions from a copyright owner, and for whatever reason those negotiations fail, you may still be able to rely on fair use with respect to the work, that particular copyrighted work. So again, it's a nuanced approach to copyright, and that's perfectly fine. The next point I'd want to make is you may have the best fair use policy available and have taken all sorts of protections and still find yourself in a defensive posture. So not to say that we've done everything right at Artstor, but we make available this library for limited purposes, these limited educational purposes. I think of them as being rooted in the First Amendment. We have all sorts of protections in place, and yet we've had a handful of copyright owners approach us with takedown notices. And so a couple of points here on that. One of them I would say is that it sounds kind of basic and simple, but be prepared ahead of time for that conversation with the rights owner. So whether you're responding to a letter or an angry phone call, because it may be your sort of only bite at the apple, and you want to frame it in positive terms, as Cherie was suggesting earlier. So you may be able to really turn around a conversation. And we've had a number of instances of that. So one example, we had this person, Donald Woodman, contact us. He's a photographer. He's married to Judy Chicago. And we had cleared the rights to Judy Chicago's works in the Artstor library, but we had not cleared his rights to the photographic works in the images. So he had photographed her works. And he contacted us initially, and it's one of those things, those Monday morning conversations. You pick up the phone and you wish you hadn't, but you pick up the phone and it was very uncomfortable initial conversation. By the end of the conversation, he was not only willing to keep his works in Artstor, but he wanted to make all of his other works available. And I think it's fair to say that he and Judy Chicago are now very supportive of Artstor. Now, it's not to say that you'll always end up in that place. You know, you're not going to always end up in that sort of happy spot. And when you don't, you have to kind of make that risk management analysis. So, you know, I say, okay, someone wants us to pull. We can't convince them not to pull. So we weigh the benefits and we say, well, what's the impact on our users of keeping it in the library? And if we pull, what does this do in terms of setting precedents? On the other hand, if we don't pull the particular work, what does this mean in terms of our relationship with this particular person? What does this mean in terms of other relationships? And obviously, what does this mean in terms of potential litigation? And this leads me to my next point, which is that there are really risks inherent in any approach. So to put a little bit of a finer point to this, we obtained permissions to include an artist's work in the library through an intermediary organization. We were subsequently contacted by the estate for that artist who said, I know you got permissions, and I'm not challenging those permissions, but I want you to take the images out of the library. And the reason I want you to take them out is I'm developing a catalog raisonné of this artist's works, and I'm afraid that having the works in Artstor will somehow impact my catalog raisonné. Regardless of the merits of that copyright owner's concerns, this ended up and still as a sort of risk management analysis. So we obviously weren't facing that question of, oh my gosh, we may be facing an infringement suit, but we had the same question at the end of the day. What is the impact if we take it down on our users? And what's the impact in our relationship with this person, with the intermediary organization, with others, if we leave it in? So again, the same types of risks. You may also face risks by doing nothing. And you know, here I would just emphasize with the rapidity of technological change, if you don't assert fair use in some instances, you may find that a market develops in ways that's not useful to you. And so I would just sort of keep that in mind as you're thinking about all of your different approaches. And I think one of the real values of the fair use statements that we're seeing that come out from Brandon and his colleagues and from others is that they are trying to sort of lay a stake in the ground and say, hey, this is really important and we believe this is fair use and we're going to robustly assert fair use under these circumstances. One other point I want to make about managing your risks is in the sort of mass digitization or distribution effort. So how many people in this room are engaged in those kinds of large-scale distribution efforts? Okay. Now, how many people really are engaged in them? Just no, I'm kidding. So what I would say is a couple of things. One way of looking at the copyright due diligence question, you know, this has not really been discussed, I think, enough. And it's come up in the orphan works context, but I think we need to spend as a community more time thinking about this because one of the ways we've handled this, and it's not to say it's necessarily the right way, but is to sort of put your content into different buckets based on the risk management analysis and to say, okay, we think this set of content is the riskiest, this is less risky, this is the least risky, and you spend your time perhaps focused most on the bucket that's the riskiest. That being said, I think we really need to think about advocating and articulating and advocating for clearer due diligence standards that take into account the tremendous societal benefits of large-scale digitization, and that recognize that there may still be ways to recognize and sort of respect copyright owners' interests without sort of undertaking an item-by-item due diligence analysis. It's just not possible in these larger-scale efforts. And that brings me to my last point, which is I want to urge us all to take collective action, working with entities or individuals that are in similar positions. And here I think it's important to take a look at all the tools that are available to us. Certainly the fair use statements are a really important tool in that effort. But I think we should be looking at a range of other actions. And so I would agree entirely with Cherie's point about trying to push for greater legislation. I think given where Congress is these days, I think that's writ large. I think that's probably unlikely. But I think we need to be thinking about things we can do as a community. And so one option might be to think about, I was very impressed with the documentary filmmakers' statement and their ability to obtain insurance afterwards. And so one thing I thought that would be interesting is if we had some collective financial support, a sort of fund for fair use litigation that mattered to us, either indirectly or indirectly. Because one of the biggest challenges facing all of us, as Bob mentioned earlier, is the sort of cost of litigation, and therefore the cost of being able to sort of robustly assert fair use in ways you'd otherwise like to. The other point I would make, and it's more conciliatory, is to say that I think we should be prepared as an educational community to work with rights holders who want to meet us midway. So I've always been very impressed with places like the Warhol Estate or individuals asserting Creative Commons licenses, or with museum efforts to make their content more broadly accessible, whether it's for scholarly publishing or for releasing public domain works. So there's a space there for us to work with rights holders in meaningful ways. And I think being able to do so allows us to then more robustly assert fair use in other circumstances. So with that, I'm going to turn over to
That's great. Thank you. My goodness, thank you very much. Valuable insights. And we have time for questions, but just so it doesn't get lost in the shuffle, a big round of applause for our first panel and our second panel. Thanks to all of them. And thanks to all of you, and we'll gladly have some questions. Wait. You had one in the first time. Let me hold off a little bit. Questions, new questions. Yeah, somebody hiding behind the column? Yes, indeed. All right. Let me grab that. Thanks, Jim.
I know my job.
Hi. My interpretation of today's conference, and I found it very useful, and thank you to all the speakers, was that there's a lot of flexibility here, and a lot of the conversation basically is just how much of a risk do particular organizations want to take. So with that in mind, especially since we have the privilege of having 3 lawyers here who actively deal with these issues, I was wondering if anybody, particularly the lawyers, could provide more specific information on just how frequent copyright infringement lawsuits are. Just how frequently does that happen, and how much of practically speaking, how much of a legal risk really is there in potentially more specifics? Thank you.
That's an excellent question. You want to give us an insight?
Well, yes, thanks. Copyright lawsuits are not as frequent as you might think. A lot of them get a lot of press. Particularly, there have been some high-profile campaigns by the Motion Picture Association and the Recording Industry Association that have gotten a lot of attention. The number of lawsuits filed against libraries, universities, museums, nonprofits is vanishingly small. Obviously you have the Georgia State situation, which took a lot of people by surprise. I told my clients in the research library world for about 15 years there has never been a case brought against a research library, but now there has been. So it's not that it can't happen, but it doesn't happen very often. People who have the copyright industries are really being hit from all sides right now, and they have so many problems with sort of rampant commercial piracy and online piracy of various kinds that looking into what's happening within the walls of university libraries is not a high priority.
But I want to add to that. What I've been seeing more of is threatened legal action as opposed to it materializing in any real litigation, and mostly from estates, because they're a little bit more aggressive, and have more of an emotional stake, I think, sometimes than a real. It's not necessarily rationally based. So there is some costs from the legal management side of just having to spend time and energy negotiating and managing those types of scenarios. And I also think it just depends on how deep your pocket is, and there are other factors as well.
Question? Yes, please. Say it really loudly. I'll paraphrase it.
Okay. I just wanted to say, since we have lawyers here, that universities, one of the biggest problems and the group that really needs to be educated very well are university attorneys, who are notoriously conservative. Peter Yossi, who spoke at a workshop I went to years ago, said university attorneys are so conservative that they make corporate attorneys seem positively and so I think a lot of that reassurance and education needs to be directed towards those people in universities. People who are the decision makers.
I wish I could have thrown the microphone to you.
Paraphrase it.
And paraphrasing, and I'm going to try to use a few of your words, that university attorneys are the ones who need some copyright education. This is our guest speaking, and that they are notoriously conservative and need to be opened up. Responses?
I think that's true to some extent. I think the role is to manage the risk of the university. So I think they are responding to these issues from a different vantage, and I think it's up to the stakeholders to present their cases and their needs to the General Counsel's office, and not be afraid to have the dialogue that's necessary. I don't think it's necessarily a matter of being educated as to the law, but maybe being educated as to your specific facts, and also educated as to really having a conversation about the actual risk and what are the chances, and whether the university might be willing to assume this risk as opposed to retreat from it.
There was something you said that triggered a thought. Let me ask a slightly different question. Do you think that university attorneys, and again, we're grossly generalizing here, do you think that they are more conservative, or do you think they see the issues differently?
I think they see the issues differently and are conservative in their perspective, because, I mean, that's our role.
All of the above.
But our role isn't really to be freewheeling. I mean, that's not our role. I think, that librarians and people who are involved in collections, they are playing a particular role, and we play a particular role, and we just have to figure out how we can help each other. And so, I think we are conservative because we have a big task in front of us, and that's to protect the university and also protect the individuals inside of the university. We do get sued, and we do get nuisance. We do have to interface with and manage challenging situations. But I do believe that what the statements, these codes have done, is that they have provided legal counsel with more information about what's actually happening, so that we can provide better advice.
Question right here. Yes, please.
I have a question for Gretchen. Many of Artstor's resources involve. Sorry.
That's all right. My bad.
Okay. Question for Gretchen. I know that many of our Artstor's resources have sort of complex copyright issues that they might originate from one country but owned by another country. And so I was wondering whether you could explain how you deal with the getting the right to have those things posted on Artstor. Thank you.
It's a great question, and so it's true that we not only obtain images from sources in a variety of countries, but then we also as I said earlier, distribute in a variety of countries. So much of what we spend our time doing in obtaining collections for the library is working with counsel to reassure them that what we're doing is consistent under the law. I think it was a lot harder when we started 10 years ago, and in fact, one of the first conversations we had, and this was not even with an organization outside the U.S., this was with a major university in the U.S., I mistakenly said to my boss, I will go and sit in a hotel room until this agreement is signed. I turned out to be a liar, and I would have been there for about 2 years if the hotel would have profited handsomely from me. So I think part of it is the sort of a willingness of institutions to rely on fair use or to contribute to an organization like Artstor. Now that we've been doing it for 10 years, I think there's greater comfort in the field. The other challenge obviously comes from institutions where, there are not those traditions of fair use outside of the U.S. So frankly, we often have to provide indemnifications to move this forward. And then getting back to Bob's point earlier about so much of fair use is the equities. I spend a lot of my time talking about those equities with people and about the optics. And so I agree wholeheartedly with Bob that certainly you can demonstrate fair use through something being transformative, but it's certainly not the only way. And so we talk at Artstor a lot about the sort of embedded First Amendment interests inherent in what we're trying to do and the societal value of what we're trying to provide. But it's a conversation in every instance.
And we have time for a couple more questions. I see one over here, and then I'll come back to you. Yes, please.
A number of us are.
Would you just hand that right back behind you?
A number of us here today are from state institutions, and at one time I was under the impression that a state institution had a certain amount of protection in the Constitution on being sued. Does it seem that is less so? I mean, I think that they tried using that argument at Georgia State. I don't know if it's going anywhere. Just wanted your impression about how much protection one gets by being a state institution.
Well, it is certainly the case that there is sovereign immunity for state institutions, and that's constitutional. The Supreme Court has spoken on it. That hasn't changed. I think some state institutions are reluctant to make that argument. It's not the first argument that you would have in your brief, although certainly not one you would want to waive either. And I think that was part of the thinking behind some of the institutions that were early to participate in the Google book scanning project, some of which were state institutions and thought, if worse comes to worse, we can rely on this argument. They also started with a fair use argument, though, right? That was where they really wanted to have the fight. But I think there certainly is a little bit of a safety net that state institutions could have if a fair use argument were not successful.
Bob, I think that last point, a little bit of a safety net, is a very important point. I gave away my microphone. That little bit of a safety net's important because, I mean, correct me if I'm wrong, that whatever that 11th Amendment immunity might be, sovereign immunity, it may mean there can still be a lawsuit against individuals. There can still be a lawsuit for an injunction, maybe attorney's fees, maybe, and there still could be criminal action. Don't say I have sovereign immunity, I can do anything I want, because that's criminal. So there are limits to the protection. And I promise one last question over here.
I've had various professors come to me with requests for sort of guidance or advice where to go, questions about the advisability of different kinds of scholarship. Say someone has written a history book and then they see that electronic books are becoming in fashion and how to go about that. Or someone is going to write something they're in the middle of and they want to know what their alternatives are. Perhaps this would be a marvelous next topic for a symposium on the alternatives, but what can be done pre and post? In other words, looking back to gaining back rights of something someone has written and making sure that that work gets out there and promulgated things, literature that is are in institutional repositories don't always have that kind of acknowledgement outside. So those are my questions, basically.
Well, certainly, if an author has already published something that's subject to a publishing contract, that will expire at some point, presumably. Maybe there's an out-of-print clause that says if the work is no longer, selling more than X number of copies a year, then it goes out of print and the author can get the rights back, something like that. There are also some provisions under the Copyright Act that allow for termination of prior grants of rights in older works. So those are the things that an author can do to get rights back once they've been granted away. But those are, very often, not the sort of thing that you can do spontaneously. You sort of have to wait until, the clock runs out on the rights that are already in existence.
Mm-hmm. And then do you, Cherie, in working with your faculty colleagues at Yale, do you often have questions about, I have a publication agreement, for example, what are my choices? Do some of those come your way?
Surprisingly, no.
Uh-huh.
I think that our faculty need more education on particularly the types of contracts they should or should not be signing and the types of rights they should be giving away or retaining for themselves. But we don't get a lot of those types of questions, surprisingly. We get a lot more questions from the librarians.
We will save that for the next program. And so on that happy note, I think we need to wrap up. And I thank you all very much. Another big round of applause for all of our panelists. Lisa. Thank you. Brandon. And thanks to all of you, and have a lovely afternoon.